Convicted murderer Oscar Pistorius has been released from prison and is now back home. The former Paralympic champion was placed on parole yesterday. The Blade Runner served half of his 13-year sentence for the murder of his then-girlfriend Reeva Steenkamp on Valentine's Day of 2013. The former Paralympian was released into the care of his uncle Arnold in Waterkloof, Pretoria, for the duration of his parole. While Pistorius will effectively be a free man, he will be assigned a correctional services official to monitor his behaviour until his sentence expires, and that parole comes with conditions. We take a look at this now with legal analyst Nthabiseng Dubazane. And Nthabiseng, thank you very much for your time this morning. And so just a few moments ago, we were showing our viewers a story of a woman who was killed by her lover in KwaZulu-Natal. When we take a look at cases of gender-based violence, perhaps this is one that is in the spotlight, and every now and again we manage to catch on television people who are in the dock either seeking bail or being denied bail because they have harmed their spouses. From a legal framework, just how deep does it run?
It is actually quite deep. It is so deep that the state has actually made certain provisions or special category for the gender-based violence assaults or murders, such that bail applications based on gender-based violence, I beg your pardon, fall under the ambit of Schedule 6. In the past, it would fall under the umbrella of a normal Schedule 1 if it's an assault GPH, or unless it falls under the ambit of attempted murder, then it goes into a Schedule 5. We knew what the parameters are. But because of the scourge that we have right now, we automatically know that if it is a situation where an accused person has abused their partner, I beg your pardon, they have accused their partner, then we're going to be dealing with a Schedule 6 bail application. And most of the time we have to show exceptional circumstances that would lead to the accused being released out on bail, which is very difficult to prove because there is no real definition of what an exceptional circumstance is. It depends on each and every case.
We'll get into the other cases that we see in a few moments, but this exceptional circumstance concept, we've been hearing that a lot. For instance, Bafana Mahungela, who is accused of killing Kirsten Clay, the Johannesburg teacher, was denied bail because he failed to prove exceptional circumstances. Who ultimately decides the exceptional circumstances? Because you can present your case, the state can rebut, but who ultimately decides, and what is the what guides exceptional circumstances?
So in terms of the Criminal Procedure Act, Section 60, subsection 9, subsections A to E, those are the guidelines of what exceptional circumstances would be. However, like I said earlier, there's no real definition of what exceptional is. So the judge or the person who will decide whether or not what you put before the court is exceptional is the presiding officer themselves. So they have to view all the evidence in an objective manner, not subjective in the situation. The catch-all situation is that in most Section 6, Schedule 6 bail applications, there is a section wherein you need to put in your defense. You don't have to, but it's always advisable that you do. And what you put in there usually sways the presiding officer, because sometimes if you choose not to put in your affidavit the reasons behind you saying that you're not guilty of the offense, and then the state has this mountain of evidence, then the presiding officer has no choice but to lean on the side of the state and deny bail. So most legal practitioners, I don't know why, but they choose not to put, even if it's like a paragraph of what your defense is, so that it stays in the mind of the presiding officer. And remember, whatever you put in your bail application will be used against you when you go to trial, once the matter is trial ready. So usually that's how you kind of play around the dynamics on how to put exceptional circumstances before the court. I remember in a 1999 case, I think it is S versus Janin, that is where the court was strict to say the state nor the court should not confine what is exceptional circumstances.
Nthabiseng Dubazane, Oscar Pistorius' case, yes, it's in the limelight, and a few others that are in the limelight. How many convictions is there a report back in terms of seeing convictions where gender-based violence is concerned? Also, while understanding that it's very nuanced, right, because it involves relationships. The police minister is always at pains every time he releases the crime statistics when he talks about GBV that rape either happens at a place of the perpetrator or at your own place because you know each other. And some people drop those cases, but just how many convictions have we seen?
Not very many, unfortunately, and mainly because of all the things you've cited already, that the complainants usually, they either withdraw the charges, and what we usually see is because the accused person is usually the breadwinner of the household. So the situation would be, if I continue with these charges against this person, I'm going to go hungry, my children are going to go hungry, I'm going to be destitute, etc., etc. So in those circumstances, that weighs heavily on the complainants, and then they end up withdrawing the charges. However, the state now also doesn't lightly allow such charges to be withdrawn. They still proceed with the matter, and even though you as the complainant choose not to proceed with the matter, remember, once a docket is opened, it's no longer Nthabiseng versus so-and-so. It is now the state versus so-and-so. So now the state will continue with the case, and then when it does get to trial stage, the state may declare to the presiding officer that you as the complainant be declared as a hostile witness, because now you are making the choice to withdraw the charges, and then they will rely on the factual evidence, for example, the J88 that is there, if there was eyewitnesses to the crime, if there's ballistics, if there was a gun involved, all those things, and then those circumstantial evidence apart from your viva voce evidence will be considered by the court and may likely lead to a conviction.
Nthabiseng, on the other side of the coin, do we find that there are people who abuse the system? You mentioned that South Africa's legal framework when it comes to GBV is quite strong. Are we finding that there are men who are languishing in prisons because of being falsely accused of perpetrating violence or being perpetrators of violence against women?
I recall at some stage I was once called a sympathizer because of what the things that we see in court. Unfortunately, in as much as in the public space and social media, we see a lot of these crimes. In the courtroom, it's a different ballgame. A lot of the cases that I personally have dealt with, I remember I dealt with the rape case wherein the accused did not rape this person. She was just angry that she had to spend 145 rand on alcohol 9 months ago, and this person stayed in custody for 9 months. On the date of trial, she then came out with the truth. Obviously, she wanted her money back, and the accused had been in custody and couldn't afford to pay 145 rand. We were able to bring up the money, and then she withdrew charges. Those are the kinds, I'm just giving you one example of many that I have dealt with, wherein the accused persons are charged with rape, with murder, with assault, only because the complainant is angry about a situation that did not go her way. The other flip side, which is very devastating, I must say, is wherein minors, and I'm talking about people below the age of 16, who are not legally allowed to give consent for sexual intercourse. They are out in clubs, they are out in taverns and all of those things. At 4 a.m. they hook up with a guy who is probably 20 years old, 25 years old. No one is going to ask you for your ID at the time to find out how old you are. And if this person ends up going home late and gets into trouble, where have you been all night? Then she cries rape. I also had a case like that. And unfortunately, the accused got convicted of statutory rape because unfortunately the kid could not give consent. She was below the age of 16. But these are the things that we see in court, which is very difficult to watch.
Mahlatsi, the executive producer of the show, is just taken aback because he says 124 rand, that's like 9 months, an entire pregnancy, and he's equating it to that. And so you take a look at some of the socioeconomic conditions that people are faced with, right? Are we honest with ourselves as a nation? Are we holding up a mirror to see exactly what young people are going through? And that could be as a result of whatever it is. But in your learned opinion and the work that you see on a daily basis, what do we do? How do we work around this? Because those are also some of those realities where you find so many cases heading to the courts. There's either resolutions or there isn't resolutions, and so we're going around in circles and we're screaming about GBV, but there's really deep-seated problems that, are we honest about those? Are we looking at them? And what do we do when we find them?
there really is no honesty around anything pertaining to GBV. And I think the term GBV also makes it difficult for a lot of male people to come forward with whatever violence that is being perpetrated against them, either emotional, psychological, etc., including the physical violence itself. Because when we hear GBV, all we hear is that a woman has been abused by a man, whereas gender does not say it's a woman. I think violence is just violence. That's what we see in court. There is a situation, there's a case wherein a man far bigger than his woman, he has chosen not to retaliate because he knows what will happen should he retaliate. He came with burn wounds from water, and he had gone to court on so many occasions to say, not to court, to the police station, to complain and say, I am being abused, please help me. And the police officers always say, but you're a man, how are you being abused? So there's so many connotations that attach to GBV that chide the boy children or the men from getting help, because they are the ones who are viewed as perpetrators. And us as women, I'm not taking it away from the fact that there's a lot of women who go through a lot. I myself can testify to a lot of that. But what I'm saying is that the fact that we attach GBV to only women is a problem in our society. And when you speak out on this, it is as if you are trying to shield what men are doing towards women. And that is a mirror, a facade that we live in. And when you try and tackle that, it becomes an even more problem. In divorce cases, for example, when we do with divorces, we try and mediate before we go further into the divorce. And when you go into mediation, you talk to the parties and the children involved, you find that this is a very deep situation and divorce is not going to change it. It's actually going to make it worse. So it is very troubling what our society is going through, and what social media puts out there as what is correct is not what is supposed to be done. We need to do more. I don't know what exactly, but we need to do more.
If you go to police stations around the country, whether you want an affidavit, whether you're in trouble or not, you'll find a corner at the police station, and it's the GBV corner. So, do we have enough social workers in South Africa? Are we legalizing an issue that needs, therapy even, maybe? Do we have enough of those services where communities or families are then given those kinds of, whatever you call it, skills, soft or hard skills, to be able to talk, to be able to sort things out? When people come to courts, are the social workers that actually give testimony, are the social workers up to scratch?
Sure. The social worker pandemic is real, and not that we don't have qualified social workers, they are overworked. There is way too much on their plates. There is divorce matters, there's children's court matters, there's maintenance matters, and they all have to deal with minor children dealing with all these situations. And then we are dealing, we are dealing with children who are committing offenses. So now we're dealing with the Child Justice Act, wherein the social workers have to come in to attest and assess these children to see if they have what we call criminal capacity. Because a case can't go forward if the social worker hasn't said that this child has criminal capacity. They have so much on their plate. And then we have I was talking on a domestic violence situation. The Domestic Violence Act, because of the way domestic violence is portrayed, has actually grown. It is not just what we know as somebody being physically abused by somebody. It goes deeper, and people are not aware of this. And unfortunately, the SAPS also are not aware on how deep the Domestic Violence Act goes. It is psychological abuse, it is financial abuse, it is all of these things. You can't now, it is so bad, I don't know what to say, it is so bad that when I advise men, because fortunately or unfortunately, depending how you look at it, our firm deals with men more than it deals with women. So when they are in such situations, what I advise is that before you go to the police station, rather go and approach a domestic violence court so that a court order is granted. That court order goes hand in hand with a warrant of arrest, so that should she or he, the person who's abusing you in any manner or form, continue what they're doing, when you go to the police station with a court order that has an automatic automatic warrant of arrest attached to it, the police have no choice but to act upon it. But you see, it becomes a situation where the domestic violence court is inundated with so many cases, and domestic violence court is supposed to be an urgent application, but you can put in a matter today, it'll only be heard 3 months later, because that's how long the roll is.
As you say that, how accessible is the law, Nthabiseng Dubazane, because you have studied it, you know it. Some of us are studying it on television through the Senzo Meyiwa murder trial or through every other court case that comes up, but you realize just how connected it is to you as a person. It's like the water that you drink, because we always joke about how the police are not doing their work until they're looking for you, and you're going to need those services. But people are not even aware about the basics, like when you are being arrested and what needs to happen, or the process that unfolds there. How accessible is the law in South Africa?
It really isn't that accessible, and also in the same breath, I could say it is. The government gazette is published every other week, if I'm not mistaken, wherein new laws are put out so that the public can comment on it. It's in the post office, it's in the internet, it's anywhere where it is easily accessible. But our people, I feel, choose not to educate themselves on that, on what the laws are. Would rather consume content that is destructive or that is entertaining. I'm not saying that you don't need entertainment to release the stress that any person has, but if you don't know what your basic rights are, it is a problem. I try as much as I can with fellow colleagues out there that we do as many, seminars for like $70 for a person to go in and hear what the basics are. When you talk about arrest, there is a situation where, if you recall back in COVID, wherein people were paying admission of guilt fines, the 100 rand, that's so they can be let go. What they didn't understand is that what you pay, that 100 rand, it becomes a previous conviction. Now they are getting surprised that I can't fly or I can't get a new job because now I have a previous conviction. I've never been convicted. But what you forget is that when you pay that AG, it is an admission of guilt fine. Therefore, you are guilty of the offense. Therefore, it goes on your SAP 69s. And now that is a whole train smash. Now you have to wait 10 years to clear your criminal record. So the information is there, but it's not accessible to everybody. And when somebody has a chance to know about it, they don't do due diligence, if that makes any sense. And that's what we find out there, that people nitpick what the law is without the understanding of it. And then when they apply it, it just goes downhill from there.
So we outsource our responsibility to the likes of Nthabiseng Dubazane. In a nutshell, we must also take responsibility of our lives. Thank you very much, ma'am, for your time this morning. Nthabiseng Dubazane is a legal analyst.